Vice President, honorable judges, it is a real honor for my modest person to take the floor within the framework of this procedure. I am speaking in my turn following my esteemed colleague, Mr. Jean-Paul Seguioli, to complement the pleadings and submission of the DRC on this aspect of jurisdiction, especially the territorial jurisdiction of the African Court of Human and People's Rights. We have to underline from start that the point is not to address the issue of extraterritorial jurisdiction of national jurisdiction of the respondent state. As a reminder, the territorial jurisdiction before such a court is understood according to the venue the dispute occurs. In this situation, the question to which we have to answer consists in clarifying whether the court has the capacity to decide on the violation of human rights alleged by the applicant, by the respondent state, while they have not been committed on the Rwandan territory, but rather on the Congolese territory. The answer to such an interrogation that is very important given this situation is facing two contradictory theses or assumptions. The first assumption is supported by the applicant state. The point is to answer by yes, starting on the fact that the violation of human rights were committed on the territory of a state party to the protocol establishing this court. On the other hand, the second assumption defended by Rwanda suggests that the court is not competent insofar as that the alleged violations are not committed on its territory. As a reminder, the scope of this court is determined or defined in Article 3 of its protocol. The latter reads as follows: the court has jurisdiction to consider all the matters and all the dispute referred to it regarding the interpretation and the application of the Charter, the Protocol, and all other relevant instruments relating to human rights and ratified by the states concerned. In case of contestation to know whether there is jurisdiction or no, the court decides. The DRC confirms that no reasonable interpretation of this provision can confine the competence of the court to the only case of human right violation committed on the respondent state territory, and this is based on 4 reasons supported by the DRC. First, the literal reading of this article or provision. Second, the relevant jurisprudence of this court on this very issue. And 3, the jurisprudence of the Commission of Human and People's Rights on this issue. And 4th, the principle of the usefulness of the interpretation of the preamble. Honorable Vice President, honorable judges, the very broad formulation of Article 3 suggests an extension of competence of jurisdiction of the court beyond the territory of the respondent state where violation of human rights occur. From the reading of Article 3 of the protocol, it appears that the author did not deem necessary to limit the territorial meaning or to the territory. On the opposite, it tried to divert from the authors of the ICG and the International Pact on Civil and Political Rights that were animated by the manifest will to limit the territorial competence of the European Court of Human Rights and the Committee of Human Rights to the territory of the respondent state. This stems from Article 1 of the Convention, the Safeguards Convention of Human Rights and Fundamental Freedom, according to which all the contracting parties recognize to all persons under this regulation recognize the rights defined under this convention. Similarly, it is the same for Article 2, Para 1 of the International Covenant on Civil and Political Rights that provides that the state parties to this covenant commits undertakes to respect and guarantee to all individuals on their territory and relating to their jurisdiction the rights recognized under this covenant. What we can say here is that the fact that the protocol have not limited the territorial competence to the jurisdiction like the European Convention, or to the territory and the jurisdiction like the International Covenant on Civil and Political Rights of the state party, is not done by chance. It shows the willingness to assume a broad competence of the court that has established it. This position defended by the DRC and supported by the doctrine in the field shows the point of view defended by an author regarding the African system on human rights, who is very well known, Judge Kibambai, and this is what he says, and I quote: "The violation incriminated has it to be committed in the territory of one of state party so that the commission becomes competent? It doesn't exist in the charter an equivalent of Article 1 of the European Convention, according to which these states guarantee the right of the persons under their jurisdiction. But since there is no limitation regarding the obligation of the state parties to the charter to protect the rights that it recognizes, we have to deduct that the commission is competent even if the violation imputable to a state party occurs vis-à-vis a person protected beyond and outside the national territory," end of quote. It goes without saying that what is done in the commission should be applied to the court, given the complementarity between the two institutions. Similarly, Honorable Judge Blaise Chikaya notes in his individual opinion, which is appended to the ruling of the court Morna against the Republic of Ghana and others, the following: we have to recall the terms of Article 3 that do not exclude any matter from the jurisdiction of the court as long as it is seized regarding the interpretation and the implementation of this charter or any instrument ratified by the state which is pending in terms of human rights. And he says, it is the court that should decide on it. So it is wrongly that Rwanda affirms in its preliminary submission that given the absence of a similar terminology, similar to the one found in the International Covenant on Civil and Political Rights or the European Convention on Human Rights, the court is right to limit its territorial jurisdiction to the facts committed in the territory of the responding state. This affirmation does not come from a wrong comprehension of Article 3 of the protocol, but also and above all from the jurisprudence of the court, which is in favor of a territorial jurisdiction which is wider. The second argument of the DRC, as we said it, is that the lessons drawn from the jurisdiction of the court itself lead to the competence beyond the national territory of the responding state. This court has always retained the status of state party to the protocol and to the charter as a principle to determine its jurisdiction. So the jurisdiction is either explicit. It is the case when the assumption is to consider this issue in a given angle, or implicit when cases where the question was not similar to this case. The territorial jurisdiction of this court is confirmed in a recent ruling that deserves to be evoked within the framework of this matter. So, the court has explicitly affirmed its jurisdiction through two judgments, at least, where the circumstances were calling for a very accurate response on the territorial competence on facts done and beyond the respondent state. In the case of Yakuba Traoré versus Mali, the court deemed that its territorial jurisdiction, it underlines that the alleged violation occurred on a territory of a member state of the African Union. It has, therefore, territorial jurisdiction. This position goes within the framework of its similar motivation as appearing in the judgment of March 2016 in the matter Mogande and 9 others, where the court has deemed that regarding its competence, it deems that given the fact that the alleged violation occurred on a territory of the African Union state, where the state parties are members, so it has jurisdiction to examine this matter. So Rwanda did not mention this jurisprudence, but maybe with some more judgment, we could see clearly that in these two examples, the court has admitted and widened territorial jurisdiction. Indeed, the relevant criteria to declare itself competent needs the fact that the violation were happening in a territory of the African Union, that is to say a state party of the Charter and the protocol establishing this court. It is not by chance, but the interpretation of Article 3 of the protocol is in conformity both to the general nature of its formulation and the will of its author. The other judgments of the court on the territorial jurisdiction cannot be interpreted only on the light of these two judgments. In order to establish a territorial jurisdiction, the court bases itself on the Court on Human Rights, that is to say, one state party, the respondent state, one state party who is the applicant. So the respondent state is party to the Charter, and the state party, or the respondent party. So when we use the term namely, it means that, in other words, among other things, in particular, including, so when the court talks about state party, that is to say respondent state, it means the state party, namely, for example, or among others, the respondent state. Regarding the word namely, it means in this case, in this very case, when the court says the state party, that is to say the respondent state, it means state party. Within this case, the respondent state. So in all the jurisprudence, the court does not contradict itself, and it doesn't question the state party to determine its territorial competence. It only clarifies that within this case, in this case, the state concerned is the respondent state. In short, Rwanda should not always echo the jurisprudence of the court in a selective way, in a hastily way. On the contrary, the reading of this jurisprudence showed that the state party to the protocol and the charter constitute the criteria to determine the territorial competence of the court. The condition to extend the territorial competence through a specific judgment of the court. In a very precise and accurate judgment, in the matter Bernard Mora versus Republic of Ghana and others, the court notes the following, and I quote, contrary to the text applicable to the European Court of Human Rights and to the American Court of Human Rights, the Charter do not precise any resort. The protocol do not define the competence of the court, but the court has always considered and examined its territorial competence. The jurisprudence in the field of human rights has constantly extended the territorial application of treaties beyond the borders and till areas where the state have effective control and where the acts committed by their agents under their military or political influence. Consequently, we can see a consensus so that the obligation to protect or not to violate human rights go beyond the territorial limits of the territories of states. It also notes that the alleged violation of human rights occurred in the territory of the Arab Republic, which is a state party to the protocol, but beyond the national borders of the respondent state. So the court cannot declare itself competent because the alleged violation were committed in a state party to the protocol. To exercise its territorial competence, the court should make sure that the alleged violation were committed by a respondent state or by persons under its control. From this ruling, we can see that in order for the territorial competence to be established, we need two conditions, two preconditions. That the alleged violation be committed on the territory of a state party to a protocol, first condition, and if the violation of alleged violation have been committed by the respondent state or persons under its control. This is the second precondition. As we can see it, this ruling confirms the constant jurisprudence that its territorial competence is established as long as the alleged violation of human rights were committed on the territory of a state party to the protocol. But the court just added a condition, a practical condition, that the respondent state should be the one where the perpetration of such violation is blamed for that. And given what was said, the court is going to declare itself competent as far as Rwanda has committed and continued to commit violation of human rights on the territories of the DRC, which is a state party to the protocol. The third argument of the DRC is based on the fact that the jurisprudence of the Human and People's Rights Commission is in favor to the broaden the territorial competence of the court. There is no determining condition justifying the fact of not inspiring ourselves from the Commission of Human and People's Rights as suggested by Rwanda. And this was demonstrated in the introductive pleadings of my colleague Yvon Mikashi. Indeed, this court is not the only and sole mechanism of protection of human rights who have retained the status of state parties as criteria to determine its territorial jurisdiction. It was preceded in this by the Commission, especially its decision of May 2003 relating to the communication 227/999, which opposed the DRC to Burundi, Uganda, and to the respondent state. In this matter, as in this one, the alleged violation were not committed on the territories of the respondent state territory, but rather on the applicant state territory, which did not prevent the Commission from affirming its territorial competence and jurisdiction. So Rwanda tries to weaken the DRC because saying that the Commission did not really focus on this issue. But how can we imagine that the state party to the protocol can be kept responsible only if it is perpetrated on its territory and not on a territory of another state party? Honorable Vice President, honorable judges, it is the interpretation of Article 3 of the protocol that guides us to take into account the principle of usefulness of this provision. So any possible interpretation that will decline the territorial jurisdiction of the court because the violation of human rights were not committed on the territory of the respondent state would be a very negative precedent for human rights in Africa. This is for two reasons at least. On the one hand, this would mean that would take Rwanda as not responsible for the violation of human rights, and this would be new crimes without sanction. On the other hand, such a solution would mean that we encourage or we entice the respondent state and others to go beyond the national borders of their respective territories, to go and elsewhere and commit in full impunity violation of human rights on the land of neighboring countries, and not to feel responsible of their commitments to the human right charter. That is to say that Article 3 of the protocol would be empty from its object, scope, and meaning. That is to say the protection of human rights in Africa, and it will be null and void. In conclusion, Mr. Vice President, Honorable Vice President, Honorable Judges, the Court will reject and dismiss the submission of the respondent state and reaffirm its territorial jurisdiction in addition to the material jurisdiction to consider this matter. Thank you very much.
Applicant State, you still have about 10 minutes to go. You still have about 10 minutes. Honorable Vice President, honorable judges, the Council of DRC believe they have brought they've made sufficient submissions to the court following the submissions of Rwanda. The court is adjourned for 10 minutes, a 10 minutes break. Now, the court will put questions to the respondent state. The first question will come from Justice Dennis Dominic Ajay. The questions will go to the two parties, and then we'll take a break and give you some time to organize your answers. The questions will go first of all to the respondent state, and then to the applicant state. We break to give you a bit of time to consult for 15 minutes, after which we'll come back for you to respond. Honorable Justice Ajay, you have the floor for your question. Honorable Justice Ajay, Honorable Justice Hanukam, you have the floor for your question.
Over alleged violations of rights protected by the Charter or any other human rights instrument ratified by the respondent. However, and therein lies my question, insofar as any claim by the applicant relies solely on the provisions of the UN Charter and the Constitutive Act, which in the respondent's submission are not human rights instruments, the court does not have jurisdiction over such claim. And the question is, what is your explanation of the word solely? And do you think that the applicant is relying solely on the provisions of the UN Charter, the Constitutive Act, as you have so claimed? Thank you.
Merci, honorable Anoukam Stella. Honorable juge Shafika Ben Salah, vous avez la parole pour vos questions à l'état défendeur.
Merci, Monsieur le Président. Je vais essayer d'aller doucement, comme ça la traduction va suivre. Vous liez la compétence matérielle à l'existence du différent. Pour vous, il y a une connexion entre les deux termes. La question que je pose, est-ce que votre problème c'est dans l'existence de ce différent, ou alors c'est que pendant le dépôt de la requête, ce différent n'existait pas? Parce que vous avez insisté sur l'existence du différent et le dépôt de la requête pendant l'existence, au moment de l'existence de ce différent. Donc, c'est la question que je pose. Parce que moi, quand je reviens au document, le requérant, il prouve, entre guillemets, c'est-à-dire pour lui, c'est des preuves qu'il présente, pour justement justifier ce différent. Il parle par exemple, dans le cas de l'Union africaine, il y a beaucoup de choses qui se sont passées et qui prouvent qu'il y a un différent qui a été exposé devant une certaine assemblée. Dans le cadre du processus de l'ANDA, la même chose, il y a certains faits qui ont été exposés et il y a eu un feedback, etc. etc. Donc tout ça est dans le document et je pense que vous avez quand même pris note de tout ça. Donc c'est ça ma question. Essayez de m'expliquer votre position. Est-ce que c'est le différent qui n'existe pas ou alors ce qui n'existait pas au moment du dépôt de la requête? Merci, Monsieur le Président.
Merci, honorable juge. Honorable juge Mengue, vous avez la parole pour vos questions. Merci.
Merci, Monsieur le Président. Ma question va dans le même sens que celle de ma collègue qui vient de me précéder. Juste pour demander à sa suite, pour vous demander quand est-ce que vous pouvez affirmer qu'il y a un conflit ou bien qu'il existe un différend?
That there is a conflict between the parties. What is the evidence of the existence of a conflict, according to you? Thank you. Menge, Honorable Justine, Honorable Justice Benashu, have the floor. Thank you. President, you aver that the matter is a matter of peace, international peace and security. My question is, the fact that the matter is a matter of peace and international peace and security, as you claim in your submission, does that exclude the possibility of this matter having a greater dimension of human rights? Thank you. Those are the questions for the respondent state. Now, questions for the applicant state. Honorable Justice Ajay, your questions for the applicant state. Thank you.
Thank you, Honorable Judge Ajay. Honorable Judge Stella and Anukam, do you have any question for the applicant, please? Thank you, Mr. President. Honorable Judge Anukam, Honorable Judge Mansulam, over to you. Thank you, Mr. President. I would like to have some clarity regarding the applicant. Could you please, regarding to the application filed, when the facts happened, because you have mentioned several dates regarding the application submitted before us, when did these facts happen? Thank you very much, Honorable Judge Bensala. Honorable Judge Dean, Judge Ben Ashur, over to you. Thank you very much, Mr. President. So the applicant state an interstate matter filed before the African Court of Human Rights can it be assimilable or comparable to any matter submitted by an individual for violation of a right or several rights of human rights guaranteed by African Union treaties ratified by the states concerned? Thank you, Honorable Judge, for the question to the two parties. So now it is 3:35. We will grant you 15 minutes to allow consultation. So we are going to break for 15 minutes and come back after this period of time so that we give you time to answer to the question in conformity to the order in which the questions were asked. The session is adjourned. We invite the Respondent State, the Republic of Rwanda, to come and answer to the questions raised by honorable judges. Over to you. Minutes to answer. So.
With the question that was asked by Honorable Justice Ajay, who asked us to talk about our appreciation of territorial and extraterritorial jurisdiction, particularly taking into account the Bernard Mona against Benin case. In that case, this court was actually very clear that the starting point is always that the conduct must have occurred within the territory of the state concerned. That was the starting point in that the court pointed out in that case. However, in the Bernard Mona case, the court talked about three things that might result in a different situation. First of all, the court, and one can see this in paragraph 149 of the judgment of the court in Bernard Mona, the court talked about acts and omissions that are committed within national territory, but that generate extraterritorial effects. So these are acts within the territory of the respondent, but which has an effect outside. But that's still something that the respondent has done within its own territory. The second thing that the court talks about in that case was that there are certain specific rights, and the court was very clear in paragraph 151 of its judgment that it was speaking about the right to self-determination. Certain specific rights that are stipulated in the Charter, in which, in the view of the court, that by its nature and by the manner of the right to self-determination. So it was very clear about the right to self-determination being one that also applies extraterritorially towards other people. The third thing that the court talks about in that case is it talks about developments with regard to international and regional tribunals where there has been an expansion beyond territorial jurisdiction. And there the court points to some case law of the European Court of Human Rights. However, it is important to note that actually the jurisdictional provision of this court in the protocol is not the same as the way in which the European Convention on Human Rights is expressed, and not the same as the way the International Covenant on Civil and Political Rights is expressed. The International Covenant on Civil and Political Rights explicitly says in Article 2, it talks about all individuals within its territory and subject to its jurisdiction. So it provides an additional basis to talk about extraterritorial jurisdiction within territory and subject to jurisdictions and expansion. Similarly, the European Convention on Human Rights in Article 1 also talks about everyone within their jurisdiction, and that court, the European Court, has said that use of that phrase within their jurisdiction allows that court to go beyond territorial jurisdiction. So that's Justice Ajay's question. Honorable Lady Justice Anukam asks us about paragraph 68 of our pleadings, where we say insofar as the applicant relies solely on the provisions of the Charter and the Constitutive Act, there is no jurisdiction. And the question is, what does solely mean there? So we accept that if the applicant is relying on the African Charter, or it's relying on the protocol, or if it's relying on what is properly a human rights instrument, the court will have jurisdiction. Even if in relation to that act, it also makes mention of the UN Charter, or it also makes mention of the Constitutive Act. But there are two things I think that are important. First of all, if it only relies on the Charter or the Constitutive Act, we say there's no jurisdiction. Secondly, if it relies on the African Charter or the protocol, but also mentions the constitutive act of the AU or the UN Charter, this court's jurisdiction is only to find violations of those human rights instruments. So this court can't find that there's a violation of the Charter, UN Charter, or find a violation of the constitutive act. It will have to find a violation, if any at all, only based in the human rights instruments that are concerned. And then the question by Honorable Lady Justice Shafika, and maybe if I can take it together with the question that was posed by Honorable Lady Justice Menge, because I think the questions go to a very similar point. So the question was that we link the material jurisdiction of the court to the existence of a dispute, a différend, as stated in Article 3 of the protocol. And the question is, at what time must that dispute, the différend, had existed? And our argument is that that dispute must have existed already, it must be in existence at the time when the application was filed. It must already have existed. Now, Honorable Lady Justice Shafika says, what is our position in relation to the documents? The documents that were cited by the applicant. All these statements alleging actions by Rwanda prior to the filing of this case. And our argument is that this requirement on the existence of a dispute, it has to be a relevant dispute. It has to be a relevant dispute. Not a difference or a dispute relating to other things. It has to be a dispute that relates specifically to the human rights violation submitted. So, the documents that the applicants have submitted, they allege, before the filing of this case, aggression, they allege unlawful use of force, they allege occupation, but if you look at those documents, in none of them, at that time, did they actually allege human rights violations. They do not allege human rights violations. The only documents that they have pointed to that allege human rights violations come after this case was filed, after the application. So I think this goes to the question of Lady Justice Menge, that when are we able to assess that there was a dispute, différend, between the parties? Well, all we say is that at the time when the application was filed, there was no dispute relating to human rights violations at the time. That's what we say. And if I may now move on to the question by Honorable Justice Ben-Archer. So the question says that we say that this is a matter of international peace and security, but does that exclude the possibility of a human rights dimension? I think in principle, the answer is no. In principle. Because something implicates peace and security does not automatically mean that there is no human rights dimension. But what we are arguing is that this case actually mainly concerns those political issues. They mainly concern those issues which are then couched in human rights language. And second, going back to the point that I just made, we see that from the fact that there was no dispute around human rights until this case was filed. I think I have gone through the questions posed by the honorable members of the court, and I wanted to ask whether it would be of assistance to the court for us to put some of these answers briefly in writing within a short period of time, if it would assist the court to do that.
Vous pouvez bien produire cette pièce à la cour, s'il vous plaît. Vous pouvez faire le résumé, nous faire parvenir vos éléments de réponse aussi, s'il vous plaît.
And forward it to the court. They'll be very welcome. Thank you. The applicant state, you have 15 minutes to respond to the various questions put by the court. I wish to, what you promised to forward to the court, it might be useful to forward it to the applicant state as well. Honorable Vice President, Honorable Judges, I thank you once again for giving me the floor, giving me the opportunity to react to the concerns raised by the four eminent judges in the form of questions. The first one came from Honorable Justice Ajay, and if I followed correctly, he wanted me to distinguish the procedure, the relevant procedure, given the fact that there is a procedure or there's a matter before the East African Court and this court. I wish to crave the indulgence of the court to respond in detail tomorrow for the following reasons. Here we are analyzing issues relating to jurisdiction, and from the issues coming from the registry, matters relating to admissibility will be tomorrow. And it's our opinion that this has been raised by, this issue was raised by the Respondent State in the portion that deals with admissibility. In a few minutes that will follow, we might say very little or maybe very little, and tomorrow will give us a better opportunity to give more information. I don't know if the court will agree with me, so that tomorrow in our submissions we'll be able to deal with that. The second question came from Justice Anukam, and she wanted us to indicate the period during which the alleged violations took place. I'll be very brief. Beyond what has already been said in our submissions, let me read a paragraph of the report of the group of experts of June 2022, and that is paragraph 60, which confirms exactly what we said in our application, and it's as follows. M23, that is, remain inactive until beginning of November 2021, a date on which it started a number of attacks against FARDC in the area where the borders, in the border area of three countries, Rwanda, DRC, Uganda, and soldier of FARDC, and stealing equipment and food, and these attacks and subsequent attacks got civilians to leave the area. We did say in our application that the date is relevant, and the date is 21 November 2021, characterized by the resumption of hostilities by M23. And when you mention M23, as we have demonstrated, it is the Rwandan forces. The report is voluminous, And I mentioned this, mentioning localities with serious consequences relating to human rights, killings, rape cases, and so on and so forth. This enables me to move on to the question posed by Honorable Ben which is similar, relating to how far back the facts go. Here, let me make a distinction to confirm what I said earlier, that these are matters that are notorious and they go as far as November 2021. But there has been a development on the field characterized by a resumption of acts that constitute violations of human rights, and also some of the alleged violations against Rwanda cover a period, and they where these acts crystallized at a certain point, and we'll come back to that when we start making our submissions on merit and give a chronological set out in a chronological manner how the various acts took place. But for now, the short answer is 21 November 2021. Now, the question of Honorable Justice Benasho, let me simply say that there's no similarity in any respect between the application initiated by an individual or NGO and interstate matter. In some respects, from the material standpoint, there is identity of object, that is violation of human rights. Now, if we find ourselves dealing with an application initiated by an individual NGO or interstate application, what characterize the determination of material jurisdiction is violation of human rights. But there is a nuance when it comes to the seizure, because applications relation to interstate matters, we do not know a declaration. It's sufficient that the state must have ratified the charter, but for individual applications, we have to read Article 5.3 that refers to Article 34.1. So in that regard, there is a certain nuance, a difference, such that the two may not be the same in all regards. Honorable Vice President, I believe I have answered the concerns of the Honorable judges, and if you require further answers, I will be ready to provide them. Thank you. So, answers, and as you requested, the issue relating to the matters that will be dealt with tomorrow can be deferred to tomorrow. We now call the Respondent State for its final comments for 30 minutes, final observations, following the various presentations. If you still have some observations to make, which we refer to as final observations on jurisdiction, then this is the opportunity to present them. If you have none, it's okay.
the protocol, and other relevant human rights instruments. So the argument about the use of commas or non-use of commas doesn't really take us anywhere. And then if I may come on to the question about when did a dispute arise between the parties? We already had questions from the honorable judges on this. But I just want to make one point in response to what you heard from the other side. They argue that the evidence of the existence of a dispute between the DRC and Rwanda on human rights, they said the evidence is many. And then they gave an example. They said, we see this in the last session of the Human Rights Council, which took place in Geneva in 2024. And then they argue that the United Nations Human Rights Council speaks about human rights violations. But honorable members of the court, this is exactly the point. That at the time when the application was submitted, there was no evidence of the existence of a human rights dispute. This is exactly why they are now referring to matters that occurred in late 2024, well after the application was filed. Let me turn to the arguments around territorial jurisdiction. And there, I think they made 4 points to argue that the court has territorial jurisdiction, even though these were not matters that occurred in the territory of Rwanda. The first argument that they make, they say, look at the literal reading of the provision. And then they make reference to those two treaties actually allow for matters beyond territorial jurisdiction. So they say, the applicant says, that there is no limitation of the jurisdiction of this court in Article 3. But that is not the question. The important point is that there is no expansion of territorial jurisdiction in Article 3. That is the point. There is nothing in the text of that treaty that expands the jurisdiction of this court beyond territory, unlike the other treaties that they cite. And then they refer to the jurisprudence of the Commission, and they say there is no reason not to use the jurisprudence of the Commission. But as we have indicated, the mandate of the Commission is not the same as the mandate of this court. As I indicated in my earlier submissions, one of the reasons why this dispute requirement exists is to give the parties the chance to have an amicable solution. The Commission can do that, even after something is filed to the Commission. This court cannot do that. So filing a submission to the Commission is not the same as filing to the court, and that is the reason not to use the jurisprudence of the Commission. The final submission of the other side on territorial jurisdiction, they said, Article 3, they said, would be emptied from its object, its scope, its meaning. It would be null, it would be void, if you require that acts must have been committed within the territory of the respondent state. All I will say is that this is extremely far-fetched. Article 3 will continue to be of significance, the same significance as it has had before this case. And as you have consistently held, the matters must fall within the within the territory of the respondent state. So those are my final observations on the question of jurisdiction today. And with your indulgence, at the end of the day tomorrow, the Honorable Attorney General will make submissions that wrap up the case as a whole, including matters of jurisdiction and admissibility. Unless I can be of any more assistance to you, that concludes our submissions for today.
Merci à vous. À présent, vous avez la parole, l'État requérant.
For final observations. President, honorable judges, I would like to put the scene now and try to answer within the allotted time. The first thing I would like to mention here is that we are not here making our submissions because this morning we have pleaded enough. In full humility, we hope that the honorable judges will be able to deliberate on the various arguments submitted. The second observation is that we note that in the manner of formulating observations, maybe it is better to move ahead the debate and deliberation rather than bringing new elements that were not mentioned in the oral hearing, or maybe it's better to say that nothing has to be added and not to say anything. The third comment I would like to make here is that the existence of a dispute, I think that we have demonstrated that enough. I'm not going to come back to it. We have demonstrated that it is a prerequisite to exercise the jurisdiction or no. So if it was the case, we have demonstrated it enough. So unless Rwanda says now that, for example, a Minister of Foreign Affairs can come over the weekend and come to Bunagwala or Kisangani, then go back to Rwanda, and therefore the views of the two parties will be in conformity. We should not be surrealistic. In fact, there is a confrontation and a radical opposition of points of views. Even if we follow the reasoning of Rwanda and here I would like to refer to the case of Mafumati's, how Rwanda considers today that it was in conformity with Congo. On the 21st of November 2021, in fact, tensions were prevailing, and honorable judges will have time for appreciation. Before giving the floor to my colleagues, what I would like to mention here is that law should be the basis of civilization. When individuals and states have disputes, we have to refer to a given article and to also judges, and Rwanda never wanted to face the situation before a judge. Now, they are talking about the ICG, but if you go to the ICG, maybe there will be some waverings from their part. We have to take the extreme assumption and the hypothesis. If this case is not admissible, there are so many killings. So is there any amicable settlement when there is human life which is at stake? So they are destroying, killing, committing genocide on the Congo territory, and they avoid meeting or appearing before a judge. This is the reality. So how do we have such objection if Rwanda thinks that it has valid grounds to support what it's doing? All these waverings, dilatory maneuvers. So, in a nutshell, Honorable President and Honorable Judges, really, here we are mourning in Congo. We tried amicable settlement because we are professionals. Some of us have lost their families, and all the world is watching what is happening. We can provide you with videos and press articles. How can we hear now that there is no dispute? Humbly speaking, I think that the court cannot follow Rwanda on this ground. So now, with your permission, I would like to give the floor to Professor Silva for 5 or 6 minutes, who is going to raise some of the concerns raised by the opposing party, and because the elements raised now were not provided for in their submissions, because these are their strongest arguments. Rwanda wants to be like a winner in Congo, because even they bury women who are still alive. They massacre and rape mothers, and now they come and say that these are not acts committed on the Rwandan territory, and so they cannot be sued. This is what Rwanda is saying. So now they are grasping, or rather they are sticking to the argument of extraterritoriality. So, Honorable President, kindly give the floor to Professor Marche Chokola, who is going to talk about a number of issues in relation to what was raised by Rwanda. Thank you. Honorable Vice President, President of this sitting, Honorable Judges, since this is the first time that I'm taking the floor within the framework of this procedure, I would like to thank you for giving me the floor, and I'm going to dedicate my words to some assertions made by Rwanda in the morning and in the afternoon. I will start with the last point, taking into account the fact of the time allotted. So Rwanda has talked about this issue, and I'm going to raise a point. So what we have heard is that we have affirmed that this hearing will not be dedicated to issues of jurisdiction and admissibility. But what is not mentioned from the other side, Honorable Vice President, is that they forget to say that this hearing is divided into two stages, two parts, according to the protocol established by the registry today and tomorrow. And today is dedicated to jurisdiction, and tomorrow we are going to present our submissions regarding admissibility. So we'll make oral presentations on that. Mr. President, Honorable Vice President, Rwanda has raised new elements which were not submitted before in their different submissions nor in the oral presentation. It is the so-called confusion between the territorial jurisdiction and the personal jurisdiction. In fact, Honorable Vice President, all the submissions of Rwanda never mentioned anything about personal jurisdiction. As far as we are concerned, we consider that personal jurisdiction is linked to the person that has a capacity to sue, or the person who can be brought before your jurisdiction. Trying to relate an issue of territorial jurisdiction to personal jurisdiction, while the DRC knows about all the theoretical data and elements, is a wrong path to follow. So this confusion is done in such a way that Rwanda tried to talk about the capacity to file a case before the court. The second element is to consider that the court cannot, and there is no reason for that, the court diverges from the practices of other instances regarding jurisdiction and admissibility. Honorable Vice President, honorable judges, we believe that this court is a specialized jurisdiction, specialized in Africa in terms of human rights. So it is not necessarily held to follow all the practices existing in other jurisdictions, simply because of the specificity of its jurisdiction, the territorial jurisdiction, and in view of even the cultural differences existing between some jurisdictions and the African Court of Human and People's Rights. As a specialized jurisdiction in terms of human rights in Africa and not elsewhere, not in America or in Europe, it has its own rules of procedures and rules that can permit it to diverge from the practices of other jurisdictions. The other elements I would like to raise here is the one linked to the similarity invoked by Rwanda between the provisions of Article 38(1) of the Statutes of the ICG, the International Court of Justice, and Article 3 of the Protocol, 3(1) of the Protocol, that requests the court to apply the procedure before the International Court of Justice. I would like, with your permission, and as a reminder, that Article 38(1) of the Statute of the International Court of Justice provides for, quote, the court which mission is to settle in conformity with international law the disputes submitted, implements the status, quote, conventions, either general or specific, establishing the rules expressly recognized by the states parts of the dispute. And Article 3(1) of the court, 3(1) of the statutes establishing the court, indicates that the court has jurisdiction to examine all matters and dispute referred to it regarding the interpretation and the application and enactment of the Charter, Protocol, and any other relevant instrument relating to human rights. When we invoke evoke the title of these provisions, it seems without any doubt that there is no similarity between the two provisions And this led to the adverse effect, according to the oral submission of Rwanda, that we have heard not pleadings on specificities of human rights that should mark all the reasonings and developments and international disputes of human rights. And this similarity, the so-called similarity which they try to establish, has led Rwanda to remain and to dwell on some facts evoked before jurisdiction on these or oral submissions. This in a nutshell, Honorable Vice President, Honorable Judges, the elements of answers I wanted to raise, which you will certainly appreciate when you will you are going to deliberate on our submissions. And I pray you, Vice President, to grant the floor to Advocate Marcel Nguma, who is going to close our submission this afternoon. Thank you very much. Honorable Vice President, Honorable Judges, we have developed our arguments, and I do not think that it is necessary to come back to them again at this stage. We are going to provide our notes and briefs to the court so that you better understand the substance of our submissions. It seems that there is a misunderstanding regarding the position of the DRC regarding the issue of territorial jurisdiction, and this transpired from what Rwanda said. To be brief, I would like to confirm here that for the DRC, territorial jurisdiction of the African Court of Human and People's Rights extends beyond borders of the respondent states. And as indicated before in our submission, we have 4 main arguments. The first argument is based on the drafting of Article 3 of the protocol to the African Charter of the Human and People's Rights, establishing the African Court of Human and People's Rights. When you read this article, one thing transpires clearly. It is the open formulation and the general nature of its formulation. This is not done by chance. We have carefully tried to consult the texts, the doctrine, and the opinion supported by Judge Kemambai, and his position is valid regarding Article 3 of the protocol to the African Charter of the Human and People's Rights, establishing the African Court on Human and People's Rights. Beyond that, and beyond Kemambai, there are so many authors that address this issue the same way, including a member from the African Court of the Human and People's Rights, I quote, namely Judge Chinkara, on this matter. This is the first argument, but it is not the only one. The second argument, as we have indicated before, is relating to the jurisprudence of the African Court of Human and People's Rights. We referred to 2 judgments where it appears clearly that the jurisdiction of the court could not be limited to the territories of the respondent state, but rather goes beyond. I'm not going to quote all these judgments since I did it this morning. Beyond these judgments, there are other judgments that seem not to be clear enough given their drafting and expressions used there. Maybe you can find judgments where the court says that it is competent because violations of human rights were committed on the territory of the respondent state. And you have seen that regarding Rwanda, it focused only on this wording. While if we take into account the whole set of jurisdiction of the African Court of Human and People's Rights, it's not the same drafting of the provision. In some judgment, the court says it is competent because the violation were occurred in the respondent state territory, but there are other judgments where the same court bases its jurisdiction on violations committed on the territory of a state party, and in this case the respondent state. Also, there is judgment Borna, and the question was asked to Rwanda on this, and judgment Borna has developed and advanced the issue of human rights, and we have demonstrated there is no obstacle why we should not affirm, why the court should not reaffirm its jurisdiction on the basis, the wrong basis, that the facts were not committed on the territories of the respondent state. I would like to mention the fact that Rwanda did not even mention this judgment, which is really fundamental given this matter. Now, are we going to expand on the jurisprudence of the African Court, which in fact had to decide on this a similar question when the DRC has introduced a matter opposing it to Burundi, Uganda, and to Rwanda. There was a decision very well known by Rwanda, and I don't see why the court would not be aware of such a precedent. Now, the fourth element is based on the Article 3 of the protocol establishing the Court of Human and People's Rights, and the reasoning is very simple, Mr. President. I think that you will certainly ask this question when you will deliberate. The problem is very simple. What is the signal sent to the African states? Because if the court follows the position of Rwanda, it means simply that respecting human rights, you should respect human rights as long as you are within your territory, national territory, but you have the green light to go elsewhere and violate human rights. This is what will be entailed if the court doesn't take into account the wording of Article 3 and its own jurisprudence, as we have mentioned, in addition to the jurisprudence of the African Commission of Human and People's Rights. I would like to conclude by insisting on the fact that we should not separate these four arguments because they have to be taken together. They are complementary to each other. And as you know, there is a perfect harmony between all of them. This is, in a nutshell, the additional information I wanted to raise. I do not know whether one of my colleagues would like to add something. Since this is not the case, I just have, on behalf of the delegation of the DRC and the Council of the Democratic Republic of Congo, I would like to thank you once again for holding this public hearing and for granting us time to express our position. Thank you very much. Final observation of the respondent state and observations of the applicant have been heard now. So, do you want to take the floor? Okay, over to you. Anything else to add? Yes, you have the floor. Honorable Vice President, I would like to indicate to the court that yesterday we had the similar incident where Rwanda sent its rejoinder after we sent our submission, and we had to react to its rejoinder, and we know exactly the interpretation. In fact, we could have insisted on this argument. So we believe that we have reached now the end of the hearing according to the protocol established. So when a party takes again the floor, it has derogated to the procedure. And this morning we had a pre-audience. Maybe we can also have another one to talk about these issues, because here we are seeing new elements they are raising by trying to discredit a submission and a pleadings, because we cannot plead on objections before without putting the stage of the context of any matter. For example, a number of elements were objected to. How to demonstrate there is a dispute if we do not put the context in which the fact occurred? It means simply that we can consider that what the agent said is a simple declaration with no effect on the proceedings. But if need be, tomorrow we are ready to meet in a pre-session in the same format to tackle other issues. Thank you very much. Tomorrow we are going to resume our hearing at 9 o'clock. The hearing will be dedicated to admissibility. This being said, the session is adjourned till tomorrow 9 o'clock.